This is the FM Gold channel of All India Radio. In the program News Analysis, now we bring you a dialogue on Supreme Court's concern over lapses in investigation and prosecution. The participants are Krishna Mahajan, Advocate, Supreme Court, and Murali Krishnan, Senior Journalist.
Investigating officers in criminal cases could face big trouble after the Supreme Court ruled that departmental action should be taken against them if a case ends in acquittal and an inquiry later finds that the probe is botched. In a landmark judgment aimed at ensuring criminals do not go scot-free for lack of evidence, as is happening in the increasing number of cases, and at the same time to see that innocent people are not kept behind bars for long, the Apex Court directed all states to put in place a mechanism within 6 months to ensure that the cause of justice is served. The court passed the order while acquitting a person accused of raping and killing a 6-year-old girl for a mere consideration of 1,000 rupees on the grounds that there was many lapses in the probe. What do you think of this judgment? Do you think it is one in the right direction of cleaning up the criminal prosecution in this country?
The sentiment behind the judgment is a correct one, except that a holistic view should have been taken of the entire criminal process, which involves the police, that is the investigating agency, the prosecution, and the courts, because the basic issue underlined by the court is one of accountability. And criminal law is a law which is pursued in the public interest because it is presumed that offences affect the public at large. Hence, the accountability factor should apply all the way, not only to investigating agencies and to prosecution agencies, but also to the courts. The question is that if trials take unduly long and witnesses therefore are not forthcoming, or witnesses can be tampered with, or witnesses' memory fades with process of time, then shouldn't the courts also do something about the whole process? Because what is going to happen in this is that suppose a disciplinary action is taken, then will that also continue for an endless period of time with appeal upon appeal and with no result ultimately?
But don't you think, Mr. Mahajan, that this is a first for the criminal justice administration?
Well, the unfortunate part has been that the Supreme Court has been giving judgments trying to push the executive to do what it should have done on its own in the first place. But the problem is that the Supreme Court rarely monitors as to whether its judgments of this kind in the broader public interest are complied with or not. For example, take the Supreme Court judgment laying down detailed steps as to the complete reorganization of the police force in the country, Prakash Singh's case. And till today, the judgment remains unimplemented and with no action by the state governments, for obvious reasons. This also is a judgment which affects every state government, and state governments have been given a direction to comply within 6 months. Now, only probably time will tell whether this particular Supreme Court judgment will meet the same fate as Prakash Singh's judgment concerning the reorganization of the police force. It depends upon how good state governments are in learning from the sentiment expressed by the Supreme Court, and it must be understood as a sentiment of serious concern in the public interest being expressed by the highest court in the land, on which the executive unfortunately has been silent in every state in India, including the central government.
Don't you think that one of the reasons why this particular observation came through yesterday was because of the concerns which were growing, especially in the number of shoddy investigations which are rising in this country? Don't you think what the Supreme Court had in mind was perhaps that there should be a time frame for such investigations?
Normally, the investigating officer is not an IPS officer, except in cases investigated by the CBI or national investigation agencies and all. Now, what is it that the IPS officer does in the normal investigations? Isn't he supposed to supervise precisely these factors? So therefore the accountability should be of the supervisors, because in terms of education, in terms of training, in terms of experience, the normal IO obviously is not as good or as competent as the IPS officer who has a superior training and a much superior education. That is why he is the supervising officer. It is his job to ensure that the investigation is fair and it is done within a time-bound manner. Now, why is it that till today, not a single IPS officer has been hauled up, either by the Ministry of Home or the Department of Home in the states, or by the courts, that is the trial courts, as to hold them accountable in terms of their supervision of the investigation? Simply hauling up the IO will not help. And then there are some dangers also. I hope this will not be the thin end of the wedge to turn this judgment into one of interference with the IO's final report that is to be filed before the trial court. There is an increasing tendency on the part of the supervising officers to interfere and, as a matter of fact, to claim the right of interference with the IO's final report when judgment after judgment of the Supreme Court has held that nobody at all, not even the supervising officer, can really tamper or redirect the investigation done by the IO.
In your long years of experience in the legal profession, do you see a dip, a fall in the standards of investigations, especially in high-profile cases?
There has been, but there has also been a lapse on the part of the trial court. For example, in the Priyadarshini Mattu case, the trial court judge, who was a sufficiently senior judge and a sufficiently experienced criminal trial court judge, he said, I know that the offence has been committed by so-and-so. I know that the evidence has not been produced, and yet he wrote in the judgment as if his hands had been tied. But under the Criminal Procedure Code, the judge has full power to get at the evidence, and that's his business. The Supreme Court has been saying that it is not the business of the magistrate to sit hand on hand and just watch as a passive spectator the unfolding of the trial, regardless of what happens actually in the trial in terms of witnesses being tampered with, witnesses turning hostile, and whether a fair trial is ensured or not. Therefore, surely the trial judge is the master of the trial, and he has been given enough powers to get at the truth. Now, if the trial judge himself does not get at the truth for whatever reason, and the superior courts are willing to remain silent upon what the trial judge has not done, then I guess simply asking the IO to be proceeded against is not fair.
One of the observations made by the bench yesterday was that they're suggesting training programs for investigators as well as prosecution officials. How viable do you think that is?
I don't know what data was put before the court and whether the court called for the data. And this is another one of the issues in matters of public interest, that quite often you find that the Supreme Court proceeds to give a huge important public interest announcement by way of its judgments, really without first getting to the data. I'm sure there are reviews of those training programs. The question is this: shouldn't those training programs have been called for and looked at? And there are training programs right at the highest level. There are interactive programs at the Indian Institute of Public Administration of the highest police officers. The training programs are there. The question is to isolate and not generalize. Isolate specifically as to where things are amiss or where things have gone wrong, and then to correct. To simply give a broadband kind of prescription is like prescribing that just because the doctors do not know what viral infection it is, they prescribe a broadband antibiotic and maybe hoping something will work. Now, I think there is a need to be more scientific in the process of delivering judgments by first getting at the data.
And at the same time, while the Supreme Court does not want criminals to go scot-free because of botched up investigations, at the same time there's a flip side to it also. We have a lot of under trials who've been incarcerated in jails, especially in terror cases, for very, very long periods of time. And finally, we also find out after many, many years that the investigators had botched up also, and and the cases which were foisted on these people were completely false. So that has also got to be looked at?
It has got to be looked at, and once again, you see, the focus should be on the trial court. Each magistrate in every city in India and in every area, in every state, knows which police stations are attached to his court. So it is the duty of the magistrate also to ensure that criminal law is being administered in a fair manner concerning those police stations in terms of the cases that actually come up before him.
Right.
You travel right across Punjab and you can see almost outside every magistrate's court in Punjab, prisoners who are handcuffed and are brought there with handcuffing, and hardly any magistrate asking that please produce the daily diary and show why you have handcuffed this prisoner. What they do is they bring the prisoners, keep them waiting outside the court in handcuffs, and while taking them inside they take off the handcuffs. Now surely a phenomena happening on this large scale can't go unnoticed by the magistracy. And as a matter of fact, when it has been brought to the notice of the magistracy, by and large the magistracy does not want to get into it. Now the Supreme Court long ago in Sunil Batra had said that you can't do handcuffing just as a routine practice. But it goes on. So therefore, you see, the question is this, that the Supreme Court may give judgments. The implementation in the criminal process ultimately depends upon those at the grassroots. And that is above all the public prosecutor. The public prosecutor should ensure that there is compliance with Supreme Court judgments. And if the public prosecutor does not do it, he should be held accountable by the magistrate. But that doesn't happen.
So you think there needs to be some sort of fine-tuning at the trial court level itself?
Yeah, you have to focus at the trial court. You have to focus for a fair investigation. I have yet to hear, for example, of a public prosecutor standing up and saying that, look, I'm not supposed to just achieve a target of so many convictions, but in this case, I'm sorry, the evidence is to the contrary and the man is innocent. Very frankly, we have yet to hear. And yet, in judgment after judgment, the Supreme Court has said the business of the public prosecutor is not to persecute, but to prosecute in a fair manner. And yet, that doesn't happen. In many of the cases, if the public prosecutor had really, because after all, let us assume that the police does not know the court processes. Although that would not be a very fair assumption,
right,
because they appear every day in the court. But the public prosecutor as a lawyer of the state is supposed to protect the interest of the state, not the interest of an individual, or not the interest of a government, or not the interest of a particular official. Therefore, it is in his hands basically lies the remedy of a fair investigation and a fair trial. If the investigation is not fair, and we, for example, in Delhi, we have a directorate of prosecutions. When is it that the director of prosecutions has been held accountable by the trial courts for an unfair investigation? Have the trial court summoned the director of prosecutions and said, Mr. Director, you are supposed to ensure a fair trial, you are supposed to ensure a fair investigation, and if it is not so, then you are supposed to stand up in the court or send your public prosecutor in the court with instructions to say so. But since that is not happening, and these are the cases in which it is not happening, please explain. But so far, again, I have yet to hear of any state where this kind of exercise has been done by the trial courts. So basically the focus is on the trial courts. And a disciplinary inquiry, it is doubtful whether the colleagues who understand the whole situation and the pressures that are brought upon an investigating officer and a public prosecutor would really carry a disciplinary inquiry to its logical end as desired by the Supreme Court.
Clearly then, much needs to be done to fine-tune both the investigating agencies as well as the prosecution system in this country, and I think the beginning should start at the trial court stage. Thank you.
You were listening to a dialogue on Supreme Court's concern over lapses in investigation and prosecution. The participants were Krishna Mahajan, Advocate, Supreme Court, and Murli Krishnan, Senior Journalist. It came to you in the program News Analysis, produced and presented by the News Services Division of All India Radio. This program is also available on our website, news.air.nic.in. You may email your opinion about this program at airnsdtalks@gmail.com.